Hello everyone, this is Tom Fox. I'd like to welcome you to episode 192 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by Advanced Compliance Solutions, who is leading the first FCPA Masterclass, which I'm teaching next week in Houston on September 10th and 11th. I've got just a couple of slots left, so if you'd like to learn about the best practices and the nuts and bolts of compliance, please give me a shout at tfox@tfoxlaw.com. You can also go to my website, Advanced Compliance Solutions, for more information. Today you're in for a real treat because I have Mike Shepard. He's a partner at Hogan's Level, and he is a white-collar defense lawyer and FCPA practitioner. Mike has thought about and written about internal controls enforcement under the FCPA, and he talks about where he sees this development going and how we got to where we are now. He also talks about data analytics in a best practices compliance program. The episode comes in at just over 22 minutes. I think you will find it very interesting. I hope you enjoy it. Thank you for listening. Today you're in for a real treat because I have with me Mike Shepard. Mike is a partner at Hogan Levels in San Francisco. He is a former DOJer, having worked as a chief of Special Prosecutions Division for the U.S. Attorney's Office in Chicago, also the chief of the Public Integrity Section of the Criminal Division in Washington. He was appointed by then Attorney General Janet Reno as the interim U.S. State's Attorney for the Northern District of Illinois, which is Chicago. He's been a law clerk. He went to law school at Stanford, and he is now a uber white-collar defense lawyer and practitioner in San Francisco. With that somewhat long-winded introduction, welcome, Mike.
Thanks for having me.
Mike has developed an interest in one of the things that I'm interested in, which is the internal controls requirements in the accounting provisions of the FCPA, and more specifically, the enforcement that's really ramped up in that area. He's written about this, he's thought about it, and so I thought it'd be great if we could visit and I could maybe pick the brain of a true expert in this area. So, Mike, with that, the latest enforcement action we had was, of course, the BHP Billotson case. That one gave us the largest civil fine for internal controls provisions violations to date. Is there anything that particularly drew your attention to this enforcement action?
You know, it's a good example, I think, of the increased attention that the SEC in particular is giving to the internal controls provisions. And it's not difficult to understand why they're doing it that way. For one thing, those are much easier violations to prove than actually proving that off in some foreign country where it might be difficult to gather evidence that some bribe was paid by one person to another person. So much easier for them to prove an internal controls violation. And in addition, I think the increased focus on internal controls is a reflection of the frustration of people at the government that they've been pushing companies for years to improve their compliance programs, and companies actually have improved their compliance programs, their training, their whistleblower hotlines, all that sort of stuff, but it hasn't seemed to have made a great dent from the government's perspective in the adequacy of FCPA compliance. So I think the government is now thinking, especially with some of the advances in data analytics on the accounting side, that focusing on internal controls might be an even more successful solution to FCPA compliance than compliance programs themselves.
Do you see that as really an adjunct to the government's overall enforcement strategy, or do you think they're just moving to focus more on the accounting provisions, either books and records or internal controls now, or is it something else?
I think it's a complement to what they're doing. They'd really like to prove bribery. They'd like to go out and catch people handing over large stacks of money, or catch them, employing the son of some important government official. I think that's what they really want to do, but that's really hard. And as a result, you see a lot of these cases where they're trying to prove that, and they end up reaching some settlement on these internal control violations that are easier to prove, and that sometimes companies are willing to try to roll up their sleeves and fix anyway.
Mike, you wrote an article a little bit earlier in the year entitled "Long Time Coming: The SEC's Increased Use of Internal Control Provisions of the FCPA," and in that article you detailed two of the reasons you thought there was increased enforcement action that you spoke about earlier. But then you had a really interesting point that I wanted to go into a little bit, and I'll just read the quote. It says, "Not only is the SEC looking at controls on a more microscopic level, but its predilection to pursue internal controls charges seems based on an interpretation of the FCPA that borders on strict liability. Circumstantial evidence of a bribery violation, such as evidence that some money may have left the company without proper authorization or accounting records, translates for the SEC into proof that the company's controls were inadequate." I think that's a great statement, and frankly, the only thing I would disagree with is I don't think it borders on strict liability. I think we may be in strict liability.
Yeah, I think as a practical matter with companies who, as you know, are just very reluctant to fight these cases, the internal controls provisions become a way to resolve these cases, because every time, as that brilliant passage that somebody wrote that you just read, any time there is an incident where either there was bribery or there was money leaving the company in some improper way that might have been used for bribery, the government can come down on that pretty hard and ultimately reach some resolution based on internal controls, and nobody's really checking in those cases whether the actual elements of a controls violation were met, because the statute is pretty clear that controls, of course, are based on reasonableness. You're supposed to go out and assess the risks and then make reasonable controls in light of those risks, because nobody could have a system of internal controls that is perfect in eliminating every risk. You'd be out of business because you'd spend so much money on your internal controls, you couldn't really be in business. So the whole reasonableness component tends to be an afterthought when the government is pursuing a more serious charge, and this is an easy way to settle the case. And the other aspect of that quote was the word microscopic, and by that I meant that if you ask some finance professional at some company what their internal controls are designed to protect against, the answer that you would ordinarily get would be they're designed to protect against problems at a level of materiality that matters for the company's financial statements. When the SEC is talking about internal controls, they're talking about internal controls at a very microscopic level that relates to how much money can get out of the company that can make a difference in bribing some official in some third world country, and that's a small amount of money that's miles and miles away from what might be material on a company's financial statement. And so, when you put those two things together, the notion that companies are going to be able to have effective internal controls across the board at this microscopic level of dollars, it's a lot to ask for, and to think that there's going to be strict liability for that for the company is really frightening. Now, an individual might have a little greater opportunity to defend those cases, but companies tend to roll over.
We bring up a really interesting point, which is around the issue of materiality. Of course, there is no materiality provision or limit in the FCPA. So do you advocate companies try to employ the COSO 2013 framework around compliance internal controls, or do you suggest something else going forward?
Let me make two quick points about that. First, you are, of course, 100% correct. There's no materiality in the internal controls provision, but there is reasonableness. And reasonableness is generally a risk-based concept that so you can kind of get some materiality arguments in the side door. As for COSO, I think it's a very good framework. I've cited it to the government when I'm defending or arguing about internal controls. But to me, when you're dealing with the government on internal controls, you have to be very company specific. You know, the particular risks in the particular countries that the company is operating, and sort of the experiences that particular company has had and the problems that particular company has had. That is what really needs to be the focus of your internal controls. And, you know, the COSO stuff is great, but it's pretty general.
You really point out the need to, in addition to having a sophisticated program, having a program really which looks at, assesses your risks, and then manages your risks from the internal control perspective as opposed to perhaps from the compliance program perspective. When you work with companies, do you advocate that internal controls efforts should be led by their audit department, internal audit, or is that something that you feel that corporate compliance practitioners either are able to or should lead?
Well, you know, all those people, compliance people, audit people, they all have helpful input. The place where I have actually found the most success in getting controls upgraded is in corporate finance. And if you get a really good corporate controller who understands exactly how the accounting systems work and who gets it that this is an important issue for the company, and you can kind of collect your knowledge of where the company has had FCPA issues, or more generally issues of money leaving the company in an unauthorized way that might or might not have been used for bribery. If you can get that knowledge on the one hand, and the knowledge on the other hand of some really good controller or finance professional about how the systems work, and you have motivated people trying to work together and combine that knowledge into a way to stop it, either with preventative controls on the front end or detective controls on the back end, that's where I've seen the best success.
You know, it's a very interesting approach, because what I do when I explain internal controls and the need for internal controls and how to use internal controls in your compliance program to companies is point to their currently existing financial internal controls and say, you've got the framework there. We may need to tweak it. We may need to upgrade it. We may need to add some language to your internal controls. But I try to point out to the compliance practitioners or CEO types, this is really just a financial control. And you're actually going to the financial controller types saying, these additional steps will give you an additional compliance internal control. So kudos for that insight. That's very good, and I have to incorporate that into my repertoire going forward.
Glad to help your repertoire. You're helping mine, so it's good. It's a good exchange.
All right. You touched on individual prosecutions for internal control violations, and you said something very interesting, that you see a little bit more room for an individual to fight that charge brought by the SEC. Could you really expand on that and talk about how an individual, first of all, an individual's obligations are different, I believe, than corporations under internal controls, but then how an individual might actually challenge the SEC?
Yeah, well, you don't see that many internal controls violation charges brought against individuals. There are certainly some. They kind of get a tag along when if an individual is going to get charged, they'll talk, with a bribery-based FCPA violation. They'll often toss in internal controls charges. You don't really see them much as standalone charges. There was a case that a couple of individuals settled several years ago. The name will come to me as we're talking. But that was an SEC case. It was the company was Nature Sunshine Products.
I'm sorry.
And at least that's the one I remember. And they had a couple of individuals who settled. The SEC had a couple of individuals settle an internal controls charge. That one was brought as control under the control person liability section of the Securities Acts. And the control person liability provisions give you a potential good faith defense. And you don't see too many criminal charges for this, in part because internal controls are based on reasonableness, and beyond a reasonable doubt aren't really a good mix for prosecutors, and also because in order to have a criminal violation of the securities laws, you have to have some knowing conduct. So there are all of those things give an individual a greater set of tools to defend against an internal controls charge, and in addition, of course, the individuals have a much greater motivation to fight these charges. And given that the government's record when they actually have to fight these cases is not all that great, it just kind of encourages the individuals to put up a fight.
Right. If we could turn now to some of your thoughts on data analytics. And you touched on that briefly in some of your early remarks, but where do you see the DOJ going, either through some of the public commentary via speeches, and I don't think we've had any opinion releases on data analytics, or perhaps any enforcement actions? Where do you see they're taking us, or where they want us to go with the use of data analytics in an FCPA compliance program?
Well, I mean, so far they're pretty light in terms of public pronouncements about data analytics. Where I've seen the subject come up is, for example, I've had clients who, who get religion on internal controls because they've had an issue and they're attempting to fend off a charging decision by the SEC and or the Department of Justice, and they make some real strong efforts to upgrade their internal controls as part of their efforts to convince the government that they're a good law-abiding company and should be left alone. And I've seen a lot of data analytics presented to the government in that context as a illustration of the commitment of a company to improve its internal controls and to have preventive and detective controls, many based on data analytics, that are really focused on the specific problems that led the company to be begging, groveling, and pleading in front of the government to begin with. So I've seen a lot of it go from begging, groveling, and pleading companies to the government, and I've begun to see some questions back from the government in the sort of give and take when you are representing some company or some individual and attempting to convince the government not to charge that entity or that individual. I've started to see some questions from them about exactly what the company or the individual has done along those lines. That's really where the action is for me at this point.
And have you been able to draw any conclusions, preliminary conclusions, or even thoughts on where the government might be going?
Well, I've had some success in impressing the government with companies' commitments to compliance and internal controls based on their focus on data analytics. And I would say that's the most significant lesson I've drawn so far.
Okay. What would you say, or what have you seen in terms of the government lawyers sitting across the table from you regarding their sophistication on data analytics? Is it just preliminary testing? Are they pressure testing what your client might be saying or you're saying? Or are they coming in and asking some pretty detailed questions that you're having to get some backup data to respond to?
Well, it varies from government lawyer to government lawyer, but there are definitely some people at the SEC who have heard a lot of presentations from a lot of companies, and as a result are pretty knowledgeable about what's going on in the world of internal controls.
We are unfortunately getting near the end of our time, but I wanted to ask as sort of a wrap-up question, other than the admonition to be scared, be very scared, where do you see best practices going forward in the area of internal controls or data analytics?
Well, the among the many things that is scary in this world, apart from all the potential violations and the difficulty of ensuring compliance in far off lands with different cultures. The scary thing is that as some companies start to upgrade their internal controls and use data analytics, that begins to put pressure on other companies to do the same, because the people over at the SEC, they might be impressed by the first few companies who come in that way. But as one of your prior questions reflects, after they've been there and done that a few times, they're going to have much more probing questions for the next company and the company after that. And they're going to expect more from the next company and the company after that, because they've already seen other companies plow this ground. And so it's it's one of those things you better be on the train or you're going to be left behind.
So that really companies can drive the evolution of best practices, and the government can just sort of sit back and point to the number of companies moving in a direction and take that on as the new mantle.
As the new reasonableness. Yeah, it's the great thing about FCPA law enforcement. I mean, my image of the guys over at the government is they're just sitting there with their feet up on the desk waiting for the call of the self-report, and now they're waiting to watch as companies start to improve their internal controls.
Well, Mike, I really appreciate this interview. You've given us a lot of good information to think about, and I really like your approach on getting to a controller, a CFO, a finance type to talk to about internal controls. I would have to say within corporations that I work with, those are the persons that are certainly the most knowledgeable. And when you talk about internal controls from the compliance perspective, it resonates the most with them. So great insight. And I hope that any internal compliance practitioners who might be listening to this, it'd be a very good time for you to walk down the hall, have a cup of coffee with your CFO, and start an exploration of where you might be in internal controls. I really want to thank you for taking the time to visit with me, and hope we can continue the conversation.
Pleasure talking to you. Happy to do it anytime.
Thank you.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to episode 192 of the FCPA Compliance and Ethics Report. I hope you found this episode useful. I have 2 calls to action for you. First of all, please email me any questions you might have for an upcoming mailbag episode. Second of all, please go to iTunes and rate this podcast. I look forward to visiting with you again. Thank you for listening.